there are a number of checks and balances which would suggest that proportionality, if it is required to be assessed, would most realistically be assessed at either the earlier stage, the domestic warrant stage, is it proportionate to arrest this person at all, or at the later stage, once he's arrested and his circumstances are known in the executing state, where he's allowed to raise it before the courts of the executing state.
The Article 1.3 says that the framework decision shall not have the effect of modifying the obligation to respect fundamental rights and fundamental legal principles, as enshrined in Article 6.
Yes.
Now we're talking about arrest, but isn't there a duty on any person who takes a judicial decision as to whether to issue a European arrest warrant to consider whether it's appropriate to do so?
They certainly need to consider whether or not the statutory conditions precedent are met. They might, in a most extreme case, have to consider whether there were reasons to consider proportionality at that stage, rather than leaving it to the executing state or deferring to the decision of the domestic warrant issuer. But it would be a wholly extraordinary case for that to arise in practice, because, as I say, this was an application made without notice and normally without detailed knowledge of the particular circumstances of the person concerned in connection normally with serious crimes because of the minimum punishability threshold.
Well, whether it's the prosecuting authority which issues the warrant or the prosecuting authority which applies to the court for the process, that authority is in exactly the same position so far as considering proportionality.
Yes.
So is there some human rights, I'm so sorry, there must be some human rights bar here, is there? I mean,
there is under the Act.
Yeah, which is that?
Right. The Act provides for it in Part 1, let's get you the page number.
Section 21.
So, 1229 in the hard copy, and
but this is where we're the executing
yes,
country.
yes, indeed.
But wouldn't the issuing judicial authority also have a Section 6 obligation under the Human Rights Act?
Well,
I think that may have been my Lord's question.
Yes,
well, then, the answer to that is to be found in the terms in which Article 5 is cast. And the answer is the human rights obligation is that which is imposed by Article 5. And if the court would be kind enough to turn to that, I'll make the point. It's Volume 8, Flag 71, Electronic 3788. Flag 71. Right. The human rights obligation on the person issuing the EAW is the obligation to conform to the principles set out in Article 5.1. There has to be a procedure according to law, and there has to be, as the case law shows us, a non-arbitrary decision aimed at one of the legitimate grounds for depriving somebody of liberty. The relevant one here is lawful arrest of a person against whom action is being taken with a view to extradition. So provided there is a basis in domestic law for arresting somebody in order to start a process of extradition, and it's non-arbitrary, you will have complied with your Article 5 duty.
Is it more than that, or isn't it more than that? You say non-arbitrary. Doesn't it actually have to be, in order to be lawful, a proportionate arrest?
Well, that certainly hasn't emerged in the case law of the European Court of Human Rights so far. It may, in relation, given the emergence of proportionality in the Charter, as a freestanding EU right, but obviously that only arises where EU law is being implemented. But no, so far the principles have been set out probably most clearly in Assange, which is in volume 4, behind flag 36. Although they're also again repeated in Medvedev, although Medvedev, there is a violation of Article 5.1 because there's no domestic law. But the same principles are there articulated. But Assange, volume 4, flag 36, electronic number 2738. This is a prosecutor-ordered detention, and it deals with the 5.1 claim beginning at page 2793.
Paragraph?
137, my lord.
Paragraph what?
137. 707 of the case report, 2793 electronic. And this is obviously a C case, lawful arrest for the purpose of bringing him before a court. And 139 is the analysis. You can see the review of decisions by prosecuting authorities. The expressions lawful in accordance with the procedure in Article 5.1 refer back to national law and state the obligation to conform to the substantive and procedural rules, but they require in addition that any deprivation of liberty, which should be in conformity with the purpose of Article 5, which is to prevent persons from being deprived of their liberty in an arbitrary fashion. And they say that in that case, because it's clear he was detained on reasonable suspicion of having committed an offence, that is sufficient for the purposes of Article 5. Now, of course, because it was prosecutor-led, there was a violation of Article 5.3, because the prosecutors didn't satisfy the requirement for prompt appearance before a judge or other officer, and didn't comply with the requirement for prompt appearance before a court for the purpose of a review of detention. But that's why I started with the court yesterday by making the point that the assumption there requires to be an impartial determination of an arrest warrant is just wrong. In all criminal systems, arrest normally starts with a partial decision to detain somebody. The English notion of an arrest warrant issued by a court is very much an exception. The norm is a decision, let's say by a senior police officer. O'Hara and the RUC is a good example, telling PC Plod, I suspect this man of murder, you go off and arrest him, and off he goes, a partial arrest. The protection lies in the requirement thereafter to provide him with an impartial tribunal. And that is why there is nothing, as I say, that suggests that a human rights construction require you to impose an obligation of impartiality on any person either seeking or requesting arrest, as the framework decision puts it, or asking for surrender. The judicial, the curial obligations lie on the executing authority. And that's why, as I said to my lady yesterday, it may well be an asymmetric system where the issuing authority may have no impartiality whatsoever, but the executing authority undoubtedly would have to in order to comply with Article 5.3.
So we're wasting our time getting it done by a judge.
Yes. Well, and it's certainly not necessary. Now, my Lord, my Lady, I was going to turn from the analysis of the framework decision and what we submit its true meaning is to turn to the process of drafting the Extradition Act 2003 and to make the point that since, as we know, the exact language of the Frameworks Directive, judicial authority, was adopted in the Act, it must, as a matter of common sense and also on the basis of the proper principles of construction, bear the same meaning.
Can you just, before you do that, do I understand you correctly, you get the requirement that the executing judicial authority be a court, not from the language of the framework decision, but from importing into it human rights thinking?
First principles.
Yes.
But only in that context. I mean, I noticed that the Commission's original proposal in relation to the executing authority spoke about bringing someone before a court. Yes. And in the ultimate proposal,
it just becomes
it became judicial authority.
Yes.
One would have thought there wasn't an intention to change the meaning of judicial authority there. From court. By using judicial authority instead of court, one would have thought there wasn't an intention to change the substantive position.
No, indeed, but that's because the judicial, depending on what the function of the judicial authority is, it may be different at different stages of the process. I mean, many countries nominate more than one executing judicial authority, for example, so that there may be a case where you've got both a prosecutor and a judge nominated, so that you can have the executing authority as a prosecutor for the purpose of starting the arrest process, but thereafter it may require, under domestic law norms, the court to become involved in order to satisfy due process provisions under the domestic law, as well as Article 5, 3 and 4. And indeed, we have different authorities for different stages because of our fairly elaborate appeal mechanisms. Various courts have to be nominated to be executing authorities depending on what stage you're at.
I want to ask one other question, which I think was put to the parties before the hearing. Has no other national court in Europe ever thought about this problem?
Yes, they have. We've seen Ireland, you've seen the Act, you haven't seen the case, Altaravicius, and I'll show it to you very briefly. The Supreme Court of Cyprus has looked at it, 2 cases which are actually referred to in the judgment. And I've had delivered to me, I haven't actually read, but I read it in Italian, and my Italian's even worse than my Dutch, a case called Piaggio before the Court of Cassation in Italy, which dealt with a German request by a prosecutor and upheld it as being within, I think, the Italian domestic law, which imports the framework decision. But because the Italians imported the framework decision in a rather curious way, until I've looked at it, I'm not sure how far it's going to help your lordships. But yes, so you've got 3 judge-led countries, Ireland, Cyprus and Italy, all of whom have grappled with this and said it's acceptable under the framework decision. So, my Lord, I was going to go to the Act itself.
Just before we leave the last point, you accept that the executing authority basically has to be a court?
For the hearing, unquestionably.
Yes. So what's the meaning of the table that we've got, in which there are 3 countries, at least, there may be more, but I've identified 3.
Yes.
where the executing